Hey friends, in anticipation of tomorrow's hearing, I thought I would give what is my estimation of their best arguments tomorrow. I want to be clear, both of these parties are represented very well by attorneys, and we really don't know exactly what the court is going to be most focused on. But I'm going to let you know, if I was representing both of these, here's what I think from the information that's been made available to the public and to me about this case. This is the argument I would say. Now, remember, Dakota will get to go first, I think, unless the guardian ad litem gets to chime in. And if you want to hear my take on the guardian ad litem, you got to watch my other video. All right, I think Dakota has 3, maybe 4 really solid arguments. The first is one of kind of procedure. We've got this dynamic where he's now filed a motion to set the stipulation aside. Utah courts really don't like ping-ponging custody awards. They like to either have something on a trajectory to get more, or they like to just have it stay consistent. What they don't want is to say, okay, from August until February, or whenever Taylor began filming The Bachelorette and not exercising the entirety of her parent time. I understand that she was exercising some, but not the entirety. So we have this position where we say from August until February, March, when the protective order was filed, Dakota and Taylor were exercising this one parent time structure. About a 60-40, I understand. Then we say, okay, then we switch, and Ever gets used to from March, April, May, and then we're going into June. So for the last 3 or 4 months, and whatever time they were filming in on The Bachelorette, Ever has consistently been with Dakota. And because they filed the motion to set that stipulation aside, the concern I would advance is, Your Honor, if we have this trajectory, we have this stability, this stable relationship of at least some supervised parent time during the week, if we revert back to the stipulation that on July 13th, we're going to have a hearing about whether or not it should be set aside, then that's really ping-ponging. We go from order to not order and back again. I think a better argument is to say we keep the parent time trajectory until we know what we're doing with the stipulation. And because the stipulation is the subject of a proceeding on July 13th, I think the best argument to make at the jump is to say, I think the time for us to look at changing parent time would really be at the July 13th hearing. The second argument I think Dakota needs to make is really focused on how is Ever doing these last few months. I want to not have the dialogue be, well, he really misses Taylor during the exchanges, because we're going to hear that, and I'll get to her case there. But I want to know from the doctors, from DCFS, from third parties, is Ever doing well? Because if, in fact, the arrangement that they have right now, Ever is comfortable in, again, the continuity of care argument, I think, has some merit. The third is that, look, I don't think Taylor has done herself any service with how she's behaved online. I think it's kind of twofold. The first is she has been speaking indirectly, quite negatively of Dakota. I think when you continue to marshal this narrative that, you guys just don't know, at some point I'm going to tell you how terrible he was, that's sort of been one undercurrent. And the other issue I think is absolutely going to come into play is the fact that Taylor has also demonstrated some chaotic behavior with her castmates. And that undercuts the argument that Taylor was advancing that she's really only reactive to Dakota. But because now we have fairly incontrovertible evidence of her being quite reactive to both Macy and Michaela, we've got now other dynamics that show, look, maybe Taylor is more unstable than we would like to believe, and that's not really Dakota's fault. The fourth argument, and again, I don't know what the status is on this, so that's why I'm saying it's a 3 or a 4, is what parent time has Taylor been exercising? If the reports that she's not been exercising all of her parent time from the last hearing forward proves true, I think that's a problem. If there's reports that she didn't show up to visits, if there's reports that she ended visits early, if there's reports and we know that she had parent time on Mother's Day and she spent a significant amount of that time engaging in social media. So I think some of Taylor's behavior is going to be the focus here. My advice to Dakota is, unlike the last hearing, take some damn accountability for your own actions. Portraying yourself exclusively as a victim of domestic violence, in my estimation, doesn't lend yourself to a lot of credibility. Being able to say, look, I've messed up, but I've really recalibrated and I'm in a better place than I've ever been because I'm doing this for my son, is probably the best. See, we just don't know where and how Dakota's sort of handling things because he hasn't been on social media. And that's one of the benefits of not being on social media, is that we really are going to only learn about how Dakota's been handling things based on the representation of his attorneys. So that's I think the best arguments for Dakota. Now, I think Taylor also has really strong arguments, and we're looking at the strongest one here, that Taylor is the conduit by which Ever's relationship with his kinship relations, the other children that Taylor had with Tate, is really, really vital. I mean, that has fundamentally disrupted his schedule. And so if I'm Taylor, the first thing I'm saying is Dakota and I agreed in the August 2025 stipulation that I would have the majority of parent time, in large part because of her, one, consistency as the parental caretaker. I don't think that there would be incontrovertible, I think it would be incontrovertible evidence that Dakota hasn't been the primary caretaker except for the last few months, but that for the majority of Ever's life, he really has been safest with Taylor, and that was an agreement of the parties. You see, I think Dakota is focusing in sort of on this last period of time. And if I'm Taylor, I need to expand out. I need to say, look, in the totality of Ever's life, not just the last 4 months, but since he was born, I was the consistency. I've maintained that. And so I think her best argument is to say, we made this agreement, and there's a lot of reasons why we made this agreement. The family dynamic is certainly one of them. Now, the second issue that I think she absolutely should raise, and I want to also just take this minute to caveat, both of their arguments may shape differently depending on what the assessments show from the DCFS domestic violence and the mental health assessment or the substance abuse assessment, whatever one's ended up having. So I could be totally wrong. We haven't seen those. I'm sure that will be the subject of some of tomorrow's discussion. But outside of that, I think this is a really compelling argument. The second is, I do think it's really beneficial to her that she purchased a home, that she's demonstrating more stability, that ultimately, in comparison to Dakota, she has a very different home life forever, that she's not living with roommates, that she's not, and with all due respect to Dakota's roommate, I think that there are some problems with his history, certain things that have been advanced about his criminality. And so I could see that being one of those concerns that she ends up raising. I think another really strong argument that Taylor can marshal here is not only that we agreed to this, but that the statute really, the Utah statute with respect to parent time of a kid Ever's age does support having one primary parent versus an kind of ping-ponging back and forth. And ultimately, that's what she's able to provide, that she had that by agreement of the parties, and that ultimately there isn't anything that's showing she's a danger to Ever. Look, the ship to sort of talk about how terrible she's been to Taylor has sailed. We know that. We have the evidence of that. The permanent protective order is the evidence of that. And the fact that neither party sought to amend or to object to the commissioner's recommendation means that that permanent protective order is not going to be modified in this action. And so the dialogue between Taylor and Dakota, okay, fine, that's kind of old news. I want to know, what's the argument about her actively hurting Ever, or her not being safe to Ever? And that very well could be one of those facts where we say there just isn't. There has to be a sufficient basis for that. Now, the fourth and perhaps other really strong argument Taylor needs to advance is that under Utah statute, supervised parent time is not meant to be permanent. There needs to be a route by which her supervision is lifted. And I would imagine that that's principally from her doing the parenting classes or her engaging in therapies, her complying with any of the requirements that the DCFS assessment may have had her do. And so I would hope that she would say, look, I was told to get into therapy. We know she did EMDR therapy. I was told to do parenting classes. I did the parenting classes. What more do you need me to do, Your Honor, so that I can get the parent time back, or at least that I can have supervision lifted? Because it's not meant to be a permanent fix. It's certainly meant to have one in which there's a route away. So I will be tuning in tomorrow. I hope you all are tuning in tomorrow. And then I will chat with you after the hearing on my social.